This episode of Q Point Podcast is pre-recorded, produced and sponsored by Karina Quirk, broker at Next Home Experience.
Different views.
I know your story.
From different cues.
Incredible job.
He's David Quirk.
You brought it up.
And she's Karina Quirk.
Imagine.
This is
Q Point.
Joining us now in studio is Deputy District Attorney of Penobscot and Piscataquis counties, Chelsea Lynds. Welcome to the program.
Thank you. Thank you for having me.
Thank you for coming in. We appreciate it.
What first drew you to prosecution?
I came to Bangor for college. I'm from Aroostook County. I was a criminal justice and psychology double major. I really liked the criminal justice side, but it was pretty clear I was not cut out for being a police officer. So I was placed in an internship at the Penobscot DA's office, and I really just fell in love with it. I just thought it was the coolest thing. I ended up working there for the rest of the time I was in college. I got clerical temp jobs, and then I was hired permanently as clerical, and then I spent my last couple of years as a victim witness advocate. I really liked working with the victims, and I just loved prosecution, and so I decided to go to law school. I also thought I had a unique perspective because there's a lot of substance abuse in my family, and by extension, there's been quite a bit of crime over the years. And so I understand that people are a lot more than the worst things that they've done. So I really just loved the profession, and I'm lucky that I've largely kept that. I love my job. I'm really proud of my work.
What do you see as the biggest stress points in Maine's justice system right now?
Staffing. Across the board, it's staffing. We need more prosecutors. We, of course, are dealing with this defense attorney crisis for indigent people who can't afford a lawyer. It goes beyond that. We have empty courtrooms in our courthouse every day where we're not holding proceedings because we don't really have a ton of judges, but we need more prosecutors, more defense attorneys, more clerks, and more marshals.
Is there a solution?
Well, a big one is pay. These jobs just don't pay enough, especially with marshals. They have to be fully sworn law enforcement. So you have to actually go to the police academy. And people don't really go to the police academy to be a court marshal. They go to the police academy because they want to be police officers. So you end up with people who are retiring and they're still capable of working. It's a good job for retired people. It can be a good job for young people who maybe have gone through the academy enough to be a part-time officer, but not full-time yet. But if you're requiring that level of credentials, you need to pay them accordingly. And as far as the court is just so swamped right now. The court, I think, has a problem the same way DA's offices do, which is that it's a very difficult time to work in these agencies because we are so oversaturated that it can be very overwhelming to come into this job now. There's really no grace period. There's no way to train. You're just thrown in, and it results in a lot of turnover.
Now that you mention it, some of the data that you brought in particular Penobscot County, in 2019, there were 371 felony cases. In 2025, there's 806. Now, this was February of each year. How many cases are you handling?
When I started, which I started in 2020, an average caseload in our office was around 180 cases. Now we all have over 300 cases. And there's a difference in caseloads. Like when you're talking about 300 cases that have victims, I prosecute our domestic violence and our child sexual abuse. Those cases are a lot of work. It's not like just write the case and then maybe you have a trial, maybe it pleads. There's a lot of time that you have to put in with victims. So the caseloads have really gone up dramatically in the last 5 years, but comparing 2019 to 2025 is really like apples and oranges because in 2019 we had an abundance of defense counsel willing to represent indigent people and we hadn't experienced COVID yet. So those two things, really the defense crisis, even worse than COVID, have just wrecked our ability to resolve cases.
As far as the public defender's office, that must be slowing everybody down, just not having enough people to represent the defendants who are in the jails?
Yes. This can be kind of confusing because there are two different ways that people can get representation if they can't afford a lawyer. It used to be in, say, 2019, if you're looking at these statistics, there was no public defender's office in Maine. What we used was a court appointment system. So private practicing attorneys, they would put themselves on a list and say, I'm willing to take on people who can't afford a lawyer, and the state would pay them. I actually started doing court-appointed work when I graduated and passed the bar in 2019. I passed in 2018. I started my practice in 2019. At that time, the rate paid out by the state was $80 an hour, which is much, much less than what you would get on a retained basis. But there was really this attitude amongst the bar of it was your obligation to represent these indigent cases because we need them for our court to function. And then there were people like me who I was really making my living on these indigent cases because I really didn't have a retained practice yet. I was just starting out. So you put yourself on a list and you say, I'm willing to take these cases, and cases would just get assigned. And there were plenty of lawyers. Everybody who needed a lawyer got one that day. They knew who their lawyer was. I would actually go sit at the courthouse during arraignments and hope that the judge would be like, well, maybe she needs some cases, because the list was so long that it would be a while before your cases trickled in. And then there was a study done by the ACLU, and they put out this report called the Sixth Amendment Report that was examining Maine's system because we did not have public defender's offices. And there were people, and there still are, who felt like a public defender system won't work in Maine just because of the fact that we have way more state than we do lawyers. So if you take a county like Aroostook County, it's very difficult to envision a public defender's office there because the county's huge and there's not many lawyers. So it would be hard to staff it. That was what people thought about a public defender system. Whereas with a court-appointed system, lawyers will travel. You can live in Bangor, drive to Aroostook, do your cases, come back. So this report was critical of that system. It said a lot of things, but a couple of the big ones were oversight in billing. It said basically that one lawyer might bill 5 hours for an OUI and another lawyer might bill 15 hours for an OUI, and the state's just paying these bills. They're not saying, why is there such a drastic change? There was a concern about overbilling. The other big concern was that people might not be getting the same level of representation that they would if they were a retained client. Of course, we want to make sure that people are getting the same level of defense, whether or not they're paying for the lawyer or the state's paying for the lawyer. This report also had suggestions about things that should be done. And in the wake of that report, there was sweeping change. There were a lot of rules implemented. Not all of them worked or made sense. For example, they said that two lawyers couldn't cover for each other. It's very common in Maine for two lawyers, especially if they're at the same firm, say one has cases in Bangor, another one has cases in Dover. They'll say, okay, I'll cover our cases in Bangor, you cover our cases in Dover-Foxcroft. One of these rules was like, you can't do that. You have to continue your case. And the funny thing about it was that these rules only applied to these court-appointed cases. So if your client was retained, you could still do all the things that you always did. So there were all these rules that came into play, and the people who weren't making their living on court-appointed cases were like, I'm not going to jump through all these hoops. I do this out of the goodness of my heart. I'm not trying to hang up my retained practice to take on court-appointed cases. And there was this mass exodus of people off the list. Then we found ourselves in this situation where there were no defense attorneys willing to take on court-appointed cases. And I remember when we were leading up to that point, it was just crazy. We all were like, oh my God, we're going to go to in custodies and the judge isn't going to have a lawyer to give someone. We couldn't believe it. We were like, what's going to happen? This is just crazy. We could have never imagined it then. But what went on to happen is that people would go months without a lawyer in jail. And people who were out of jail, they're going 9 months to a year without a lawyer, which was just unheard of. You would have never, ever envisioned that back when this all started. They did a couple things to try to correct this problem. They raised the rate from $80 to $150 for private attorneys, and they created these public defender's offices. I think there's like 5 districts maybe that have them. We have one in our district. I actually am in favor of public defender's offices. Some people are very much against them. I think they're great because we have a problem with the fact that most of our lawyers are over the age of 65. So we need young lawyers. And Public defender's offices are good in the sense that they give young lawyers an avenue into defense work that we didn't otherwise have. It's scary to go hang a shingle. And if you're going to work for a firm, they don't really want you doing court-appointed cases because there's no money in it. I think that it is a helpful structure to have, and I think it's going to attract people to criminal law, but they were only intended to take 30% of the cases, meaning the other 70% will still need to be represented by private counsel. And I think that message was kind of lost somewhere. So people were thinking, okay, well, these public defender's offices should just come in and take all these cases. But these offices are still in their infancy. They are being staffed with young lawyers. They can't just come in and take all these people who are sitting in the jail unrepresented because these people are charged with aggravated drug trafficking, gross sexual assault against children, aggravated domestic violence assault, aggravated attempted murder. We can't just give these to young lawyers in an infant public defender's office. It's confusing to talk about because there are public defenders and then there are private attorneys who are willing to take on court-appointed cases.
Are you seeing any private attorneys coming back into the fold, or is there still too many barriers to being a public defender?
The private attorneys are back some, but nowhere near what they used to be, because when we really got into the midst of the crisis, we have people in jail for weeks and months without lawyers. There were attorneys in the area who were like, all right, I'm going to put myself back on the list. I will help out. But because there's nobody on the list, what started happening is that if I put my name on the list, all of a sudden you get flooded with cases and you have to pull yourself back off the list. So for a while, our court was trying to have a shadow list, we called it. They wouldn't put themselves back on the roster, but our judges would go to our local defense attorneys and say, are you willing to take on this case? And then appoint them. That got shut down. The attitude was like, you really need to follow our rules in order for these people to get paid. They have to be rostered and they have to go through the proper channel. So that didn't last, although it was helpful when we were able to do it. Now, people have put themselves back on the list, but they also are being regulated by a points system that didn't exist before. So they're only allowed to take a certain number of cases. All of our defense attorneys are right up against that point all the time. If they resolve one case, then maybe they can take one case, but we don't have anybody that's able to just accept appointments all the time. Like I just did our in custody hearings on Monday, and we had probably a dozen people who had been arrested over the weekend, and we didn't have lawyers to give them.
What entity makes the decision that they can or cannot be on the roster and the rules?
There's a managing entity called Public Defender's Services. They manage the public defender's offices, which are like the DA's offices, but on the defense side, and the private attorneys willing to take on indigent cases. They are the body that creates these rules.
You are listening to Q Point Podcast. I'm Karina Quirk, co-hosting with my husband, David Quirk, and we are having a discussion with Deputy District Attorney for Penobscot and Piscataquis counties, Chelsea Lynds.
So obviously, when somebody gets arrested and they are in jail, they are due process. Some of these defendants have been in jail for a few weeks, and after a while, they must get released if they don't have an attorney.
They do. What was happening in the beginning when we first didn't have lawyers to give people is people would be sitting in jail and they'd sit there for weeks or months without a lawyer. Everybody agrees, prosecutors, judges, defense, we all agree this is not right. This is an egregious constitutional violation. So we started having these 7-day attorney review hearings. What that does is it allows the defendants to have access to a lawyer of the day for a few minutes, and they get to see a judge every 7 days as long as they do not have a lawyer. So we're having bail hearings again every 7 days. And prosecutors are having to argue, okay, even though there's still a Sixth Amendment violation of their right to counsel, it doesn't justify releasing them at this point. Their bail should still stay in effect, which is a hard spot to be in as a prosecutor. Nobody wants to be arguing that people should be held in jail without a lawyer. And it's hard for judges. It's serious stuff to say as a society, we're okay with holding somebody in a jail cell and denying them a lawyer. That's scary. But on the other side, You look at what happened in the Lewiston area. There was a defendant who had been charged with a crime of domestic violence. I think he'd been on probation for domestic violence as well. He was held for a number of weeks without a lawyer. And finally, a judge said, I am releasing the hold. I'm lowering the bail, and you're going to be released because we don't have a lawyer to provide you, and we can't continue to hold you in violation of the Constitution. That defendant got out. He burned his victim's house down. He burned the neighboring house down, and the man in that other house died. And the defendant was shot and killed by the police, being taken into custody. So how you balance those two things, I don't know. There are some people that are dangerous to release pre-trial, but how you justify holding someone in violation of the United States Constitution is dangerous as well.
So speaking of bail, what can you tell us about cashless bail?
We went through a bail reform a few years ago that, to be honest, I didn't really have a huge problem with. One of the things that it did was say that people can't be held on only the bail commissioner fee. So when a bail commissioner has to come out, there's a $60 fee associated with that. So if somebody's bail is set at personal recognizance bail or unsecured bail, meaning they don't have to pay anything, the spirit of the bail is that they're going to be released. They can't be held only because they don't have $60 to pay the bail commissioner fee. And I think that's probably right. The other thing it did that was a little bit more impactful is it got rid of random search and testing for drugs. We can still random search for dangerous weapons, but we can't search people at random for drugs. We have to have reasonable, articulable suspicion, which is pretty low. It's lower than probable cause, but it's something. What would happen before, to a certain extent, it wasn't like it was abused, but we especially saw this in Bangor with the transient problem. People would get arrested. They'd get these random search and testing conditions. It's like fish in a barrel. They'd get out, they're homeless, and they would have a run-in with the police, and the police would say, okay, you have random search and testing, I'm going to search you, and they'd be in possession because they're in active addiction and they're going to use. So it got rid of that, the ability to do that. You can't just walk up to someone and say, I'm going to search you just for drugs. From my perspective, it's really kind of here nor there because we don't have the capacity to prosecute these VCRs anyway. We're oversaturated with cases. So if we miss a few cases because we don't have random search and testing, I don't have a lot of heartburn about that. But it was a tool for the police, and they lost that tool. I can see both sides of that. But practically speaking, we just have bigger fish to fry. As far as true cashless bail, I know some states do it differently. I know of a few states that have a system where instead of saying, okay, you have to have $5,000 to get out or $10,000 to get out, what they do is they engage in an analysis of, is this person a danger to the community? And if the prosecutor argues, yes, they're a danger, they prove that to a certain standard, then the person is just held without bail. There's no amount of bail that they can post. And that could be domestic violence. It could be drug trafficking. Then once they're held, they have to have a trial within a certain amount of time. If the answer is no, they're not a danger to the community, then they're released. There's no cash bail component at all. In theory, I don't really have a problem with that. Where I have a bit of an ethical issue is that there are people who, especially that are transient, have severe mental health issues. They're schizophrenic, they're off their meds, or they're in active addiction, and they have some mental health issue going on, or they're just very deep in their addiction. They come into the jail, and sometimes, more often than you would think, this is not uncommon at all, people end up getting held on $100 cash bail because they need to stabilize. They need to have a Title 15 competency evaluation, get over to Dorothea Dix, get some med management, deal with a case manager at the jail to just turn them out. It is like a revolving door. You know, you turn them out with no social support and they're just right back because they don't have the tools to not commit a crime. They are committing crimes of transiency. They're going into apartment buildings and sleeping. They're exposing themselves because they're in an episode of psychosis. And we do that a lot, especially we're in Maine. When you know it's going to be negative 10 degrees and you're looking at a person who's schizophrenic and off their meds, to turn them out is just inhumane. With a true cashless bail system, you kind of lose the ability to hold someone like that. And what proponents of that system say is that those people shouldn't be dealt with in the criminal justice system. That's not where they belong. They don't belong in jail. And I agree with that. They don't belong in jail, and we shouldn't be taking up the little resources that we have on people who really need social services, not criminal justice services. No one wants to stick these people with a criminal conviction. And I agree with all of that in theory. But in practice, when you're looking at someone who has nowhere to go and they need stabilization, it's just a different thing. It's just hard to know the right thing to do.
So we hear a lot about these defendants that are called catch and release 13, 14, 15 times. Can you explain some of that?
Sure. Unfortunately, we do have a lot of that. We have many people who are on 10, 12, 15 sets of bail, have 15 active cases. Usually what that is are people who are committing crimes of transiency. Retail theft is a big one. People will say, go into Shaw's and take food off the hot bar and walk out. They'll steal nips of alcohol. People will be driving with a suspended license, going into empty buildings and sleeping. We're not going to hold those people. And this really changed a lot around COVID because we had to really be cognizant about who we were holding in the jail because they have to go into quarantine. We have to follow these social distancing protocols. And we were trying to limit how many court proceedings we had to have. Bail changed a lot around that time. It's mostly the people being held pre-trial at this point are people who are either violent offenders, sexual offenders, big drug traffickers, or mental health issues. It's very difficult to hold a non-violent offender pre-trial without some specific reason.
What risks do you see if this backlog trend continues into 2026 and beyond?
The real risk is these middle-of-the-road cases. We have cases that we're always going to prosecute. Aggravated assaults, domestic violence assault, drug trafficking. We're always going to prosecute those cases as long as we have prosecutors. And then there's, on the other end of the spectrum, operating after suspension, for example, or operating with a suspended registration, things that are really easy to deal with. You're never going to be worrying about a jail sentence or something on those. And when a prosecutor screens a case, they take it in for the first time, they have to say at the outset, I'm asking for a jail sentence or I'm not asking for a jail sentence. A person has to face a real risk of jail to qualify for a lawyer. We're already seeing the effects of this. What we used to do is say you have a transient who is committing these petty crimes at a business. They're yelling in front of a business. That could be a discon. They're maybe damaging a sign or they urinate. The police come, they try to move the person along. They can't. So the person gets arrested. If the person had some kind of severe mental health issue or they're really bad in active addiction, we used to be pretty willy-nilly with our jail certifications. We'd be like, okay, well, this person could use a lawyer. Then the lawyer can help get them in touch with services and get them into a group home or get them into a rehab or get them a competency evaluation. They would just benefit from having a lawyer. We would certify jail. We can't do that anymore because we have to save our jail certifications for these cases that we really need them because we don't have the lawyers. And we're already seeing the effects of this because business owners, they call the police come arrest the person, we decline the case, and then the business owner is feeling like, what the heck, I'm here, I'm a contributing member of society, I'm trying to run a business, and the police aren't doing anything because the police are saying, well, the DA's office isn't going to prosecute it. And they don't understand that the only option, because we can't just certify jail anymore if we're not really looking for it, is what? Give this person a fine? Okay, they're homeless. They're in a psychotic episode. What is the point of giving them a fine and a criminal conviction? So what? So the police can go run around and arrest them for unpaid fines for the next 10 years? It makes no sense. So the cases that are going to suffer, it's these middle of the road cases where maybe it's not violent, it's felony possession, it's crimes of transiency, it's repeated operating under the influence. It's these kinds of crimes that affect society and they erode confidence in the justice system. That's the risk.
Obviously, you could be making a lot more money if you were with a private firm practicing versus being a prosecutor for Penobscot County. How do you feel about that?
That's the truth. There's private attorneys. Certainly, I could make a lot more money doing that kind of work. And even if I was a private attorney who was willing to take on court-appointed cases, Then you can have a mix of retained clients and court-appointed clients. And even with the court-appointed clients, $150 an hour, it's less than a retained rate, but it's a lot more than what I'm making. But you really can't compare prosecutors to the private sector because we have a lot of things that they don't have. We have loan forgiveness. We have great benefits. We don't have overhead. We have a regular paycheck. We don't deal with a lot of things that they do have to deal with. Where the tension has come in is the public defender's offices, who were, by all accounts, supposed to mirror the district attorney's offices. They have similar things as we do. They have a staff. They're funded by the state. They have loan forgiveness, these kinds of things. They are getting paid more than the prosecutors. An assistant public defender with 5 years experience compared to an assistant district attorney with 5 years experience, they're making $20K plus more. That wasn't the intent of the legislature, I don't believe. We had a bill go up to try to correct that and give us equal pay. That was carried over.
How did that affect the morale in your office?
Morale was already low because we are drowning in our caseloads. A lot of people have left the profession in the last few years just because it's been so difficult. It's affected morale a lot. It just feeds into this narrative with prosecutors that we don't have any support from Augusta and there is no help coming and they don't care what we're going through.
Thank you for joining us for part 1 with Deputy District Attorney for Penobscot and Piscataquis Counties, Chelsea Lynds. Make sure to tune in tomorrow, Sunday, September 28th at 6:30 a.m. on VOM, The Voice of Maine. You don't want to miss it.
You've been listening to Q Point.
Follow us at qpointpodcast.com or on your favorite streaming app.
This is where you can get the news from the people who make the news.
Make sure to join us next time.
We hope you tune in.
Q Point Podcast invites guests and candidates from all parties to join the conversation. The views, information, opinions, and comments expressed during this program do not necessarily represent those of the host, Q Point Podcast, associates, affiliates, and CQRE LLC.
Thanks for being a part of the conversation. Catch every episode at qpointpodcast.com or wherever you stream. Tune in and tell your friends.